Good morning, everyone. My name is Rachel Carruthers, and I'm the events manager here at the Portland Regional Chamber of Commerce. Welcome to Growth Basics for Business, a monthly breakfast seminar series which provides a forum to gain useful do-it-yourself workplace solutions and insightful actionable tips. Today is our third event of the 2024-25 season of Growth Basics for Business, and I want to thank Eaton Peabody for their continued support of this virtual event series again this season. This morning's topic, Need to Know Maine Paid Family Medical Leave, is presented by Jack Bjorn, Associate in Eaton Peabody's Labor and Employment and Employee Benefits Practice Groups. Today, Jack will provide an overview of the most recent rule changes to the paid family and medical leave law, as well as provide a refresher on Maine's earned paid leave law. His presentation will highlight the important details of the program's eligibility, the reasons individuals will be able to take paid leave, the law's application to large employers versus sole proprietors, and the law's impact on private plans and collective bargaining agreements. Like all the Chamber's virtual signature events, today's presentation is free and is being recorded. It will be made available for free replay on the Chamber's website and YouTube page. To keep up to date on all the Chamber's news and events, visit our website, portlandregion.com. Check out our events page and sign up for our weekly email newsletter while you're there. Before we begin today's program, I just want to remind everyone that we are using a platform called StreamYard. This platform provides improved production and interactive elements that truly enhance our virtual events here at the Chamber. On that note, I'd like to point out that when you have questions for our presenter today, you can type them in the YouTube chat. Jack has reserved time at the end of his presentation for a Q&A session with everyone here this morning, so please do not hesitate to engage in the conversation. And at this point, I'd like to introduce Nate Levesque, Director of Marketing for Eaton Peabody, our Growth Basics for Business series sponsor.
Great. Thank you very much. First of all, I want to thank the Portland Chamber for doing such a great job of putting these together, providing new and engaging content month after month. I also want to thank our presenter, Jack, for taking the time to present on this very important topic. Lastly, whether this is your first Growth Basics event or your 10th, I want to thank you all for taking the time to join us this morning. For those of you that may not be familiar with Eaton Peabody, we are a full-service Maine-based law firm with 45 attorneys serving Maine clients from offices in Augusta, Bangor, Ellsworth, and Portland. We assist companies of all sizes in a variety of industries, so whether you're an established financial institution or small business just taking your first steps, we can help with all of your legal needs. To learn more about the services that we provide, the industries that we serve, please visit our website, eatonpeabody.com, and also be sure to follow us on Facebook and LinkedIn to stay up to date on legal updates and future presentations, which I'm sure there'll probably be a future presentation on this topic in the near future. So thank you very much, and back to you, Rachel.
Thank you so much, Nate. We're so pleased to have you here this morning. And thank you so much for your support of this series. So now, just to tell us a little bit more about our presenter this morning, I'm going to welcome to the stage my colleague, Eamon Dundon, Director of Advocacy here at the Portland Regional Chamber of Commerce.
Good morning, everyone. Great to join you this morning to talk about one of our favorite topics at the Chamber, paid family medical leave. We've been on this issue from the very start, back when it was just in study mode, all the way through the adoption of the legislation, the various phases of rulemaking, and now in just a couple short weeks, the implementation of the program. And we'll continue to be with you, sharing updates and sharing our concerns and comments to the Paid Family Medical Leave Authority as this program rolls out and we hear more from you, our members. So without further ado this morning, I want to introduce our presenter today. Jack Bjorn is an associate in Eaton Peabody's Labor and Employment and Employee Benefits Practice Groups based in Portland, Maine. He counsels clients on all aspects of labor and employment law, including statutory and regulatory compliance, employer policies and procedures, and claims before the Maine Human Rights Commission and other state and federal agencies. As part of his employment practice, Jack regularly assists private and public employers, colleges, and universities with general employment compliance issues such as employee handbooks, family and medical leave, employment contracts, wage and hour issues, employee disciplinary matters, and labor negotiations. Jack Jack's work also includes employee disciplinary matters and labor. Jack's work also includes counseling clients regarding employee benefits, executive compensation, retirement benefit divisions, and maintenance of both tax-qualified retirement plans, as well as plans for tax-exempt and governmental entities. And so now, without further ado, I'd like to turn it over to Jack, and then I will rejoin you all for the Q&A at the end of Jack's presentation. So please, Jack, take it away.
Good morning, everyone. Thank you. I'll echo Nate's sentiments as well. Thank you to the Portland Chamber for having me back for another round of proposed rulemaking updates regarding the paid family medical leave program. Back in the spring, was fortunate enough to do another presentation, and I'm very happy to be back to provide another update on the most recent changes to the program. So with that, I think first and foremost, we'll say that my goal today is to provide a brief summary of the program, surface level, high level overview of the program and where things stand, and then go into an update on all of the new changes that have come in the second round of proposed rulemaking in the last couple months. So with that, just as a recap, last year in July, Governor Mills signed the paid family medical leave program into law as part of the state budget for 2023. Maine is the 13th state to enact such a program, as well as the District of Columbia. And under the program, beginning in 2026, eligible workers in both the public and private sectors will be eligible to take up to 12 weeks of paid leave. The program will be administered by the Maine Department of Labor and covers eligible employees of eligible employers, including private businesses, the state, municipalities, and tribal governments. The program will provide up to 12 weeks of paid leave in a benefit year, defined as the year starting on the first day when leave is taken, which may be taken intermittently in increments of not less than 8 hours or on a reduced leave schedule as agreed to by an employer and its employee. Those smaller increments can be as small as 1 hour. Continuing the recap, reasons for paid family medical leave for taking leave include to bond with a covered individual's child or adopted child, to care for a family member with a serious health condition, to attend a qualifying exigency, to take care of a family member who is a covered service member, to take safe leave as defined under state law for violence, sexual assault, or stalking, for personal medical leave for a serious medical condition, to donate an organ for a human organ transplant, and for leave following the death or serious health condition of a family member who dies or incurs that health condition while on active duty as a member of the armed forces. The program will be funded by employer and employee premium payments that will begin this coming January on January 1. The premium payments may not be more than a combined 1% of wages. Employers with 15 or more employees may deduct up to 50% of that premium from the employee and then is responsible for paying 100% of the combined premium to the benefit fund. Employers with less than 15 employees may deduct 50% of the premium from that employee's wages and shall remit that amount to the fund. Notably, employers have the option, they're not directed to, but they have the option to pay the employee's portion of the premium as well. Benefit payments. So the benefit payments are formulated based on this formula set out in statute. It's a little confusing to say, but hopefully will be a little more understandable when I get into the examples in a moment. But covered individuals are eligible to receive up to 90% of their average weekly wage that is equal to or less than 50% of the state average weekly wage, and up to 66% of their average weekly wage that is more than 50% of the state average weekly wage. Again, confusing, but when you actually put it down on paper, it's a little easier to grasp. Notably, as of this past year, this last July, the state average weekly wage was $1,144.67. That's updated every July, and then the new updated state average weekly wage will be used each year to calculate benefits. These two benefit calculation examples are taken directly from the Department of Labor presentations that they've done. I feel like they pretty well describe what this would look like for somebody that wants to take leave, and gives you a good idea of how the calculation takes place. So Morgan is a full-time accountant and earns $57,000 a year. Morgan needs 8 weeks off to care for a family member with a serious health condition. Morgan's average weekly wage is $1,096 or $57,000 a year divided by 52 weeks. Morgan's weekly deduction from her paycheck into the Paid Family Medical Leave Fund is $5.48 per week or $285 per year. Again, that's 0.5% of her total salary for the year. With respect to the Tier 1 calculation, that's the 90% wage replacement on earnings up to 50% of the state average weekly wage. There, you multiply 1,144 by 50% to get $572. 90% of $572 is $514. Tier 2 calculation is 66% of the wage replacement on earnings exceeding that 50% of the state average weekly wage. Morgan's remaining earnings are $524. That goes back to her average weekly wage of $1,096. Subtracting $572, 66% of 524 is 345, and therefore combined, Morgan's weekly benefit that she'll receive from the program is $859. Because she has not reached the cap of the state average weekly wage, she'll be entitled to that full amount. The second example is to try and show what the benefit would look like for somebody that would exceed the benefit cap. So here, Joe is a full-time employee, earns $90K a year, and Joe needs some time off to recover from surgery. Joe's average weekly wage is $1,730 or $90,000 a year. Joe's weekly deduction is $8.65 per week or $450 per year divided by 52 weeks. The Tier 1 calculation is 90% again. So that's 1,144 times 50%, which is 572, and 90% of 572 is $514. The Tier 2 calculation is 66% of the remaining wage on earnings exceeding 50% of the state average weekly wage, and Joe's remaining earnings are 1,158 or 1,730 minus 572. Once you do the 66% of that amount, you get 764. So Joe's total weekly benefit for the next 4 weeks, when you add those two tiers together, would be 1,278. But because that exceeds the state average weekly benefit, Joe's benefit is capped at $1,144 and change. Just a quick summary of where we are to date. Again, last year, the state budget went into effect, the effective date of the Paid Family Medical Leave law. This past January, the Maine Department of Labor began its rulemaking process. That's included Q&A sessions with the public. It's included 2 rounds of proposed rules and a lot of seminars, some of which that are publicly posted on the Department of Labor website. As far as next steps, on January 1 of this coming year, the initial Paid Family Medical program rules are anticipated to be adopted, the final rules. Also in January, employer-employee contributions to the program begin. Starting in May of 2026, the claims for benefits will begin being processed. So again, just as a little bit of a reminder where things stand, in August, the Maine Department of Labor released its second round of proposed rules. There were public comments due on September 30th. The final rules, again, are expected by January 1, 2024. I'm certain that there will be tweaks and perhaps legislative amendments as things play out in the next year before benefits begin being paid in the following year. But the final rules are expected in January. Importantly, the DOL continues to update the FAQs and provide other resources during the rulemaking process. So I'll say this now, and I'll probably say it again, but the DOL Paid Family Medical Leave website is a great place to go for all you need to know on paid family medical leave. There's a place where you can sign up for updates so that anytime there's an update to the FAQs or rules, you'll get an update directly to your email. They also have a bunch of resources there, including the text of the act, the text of the rules, and recorded presentation sessions or Q&A sessions that you can review to get a better understanding of the program as well. So this portion of the program, again, just wanted to go through the notable second round changes. So this doesn't include all of the rules as described in the first round. but simply provides an update on what has changed from round 1 to round 2. Certainly happy to answer questions, at the end of the program as time allows. So one big important change that the DOL made was removing quote unquote on the affinity relationship from the definitions. Now, family member has the same definitions as under state FMLA law, including someone who with whom the covered individual has, quote, a significant personal bond that is like a family relationship. I suspect that this was intended to be a little more tailored compared to what affinity relationship was defined as before. That will probably reduce the headache, hopefully, of somebody trying to say that they need to take leave for their best friend John Smith down the road, who's like a family member. And there are certain factors that I'll get to on the significant personal bond later in the program. Wages has also been updated to include all remuneration for personal services, including tips, gratuities, severance pay or termination pay, commissions, and bonuses, excluding wages over the Social Security taxable wage base. If I remember correctly, the Social Security taxable wage base is approximately $150,000 this year, so there won't be that many employees in the grand scheme of things that that portion will affect. Types of employment. The second round of the rules clarified that employees that are not covered on the program, again, include railroad employees, incarcerated persons, students earning wages through the federal work study program, and employees of the federal government or who volunteer for an employer or governmental entity. Notably, with respect to the federal work study program, if you have a student at a university who's working in a cafe, those wages would count towards the program. But if that student is working as a teaching assistant or a research assistant, and those payments are through federal work study program funds, that time would not be included for purposes of the program. With respect to eligibility, to be eligible for the benefits, a covered individual must also be employed as of the date of application for benefits if applying in advance of leave, or be employed as of the date leave begins if applying retroactively. Paid family medical leave will be reduced by any leave taken under federal or state FML that was not taken concurrently with paid family medical leave in the 12-month period preceding the start of the leave. In some of the info sessions, the Department of Labor has said that it anticipates providing additional guidance on a look-back period, similar to look-back periods of other state paid family medical leave programs. The idea is that that would look back 3 to 6 months for purposes of making those claims. Notice of undue hardship. Importantly, Maine is the only state with an undue hardship provision. I think this will be a beneficial provision for businesses in the state that might have a hard time with staffing challenges if somebody is anticipating going out on leave. The notice of the intent to take leave from the employee must be in writing. If the employer and the employee agree to a leave schedule, the employer can waive the 10-day review of the undue hardship on a form provided by the Maine Department of Labor. All forms at this point are forthcoming. I think the department has been pretty busy trying to get these rules in place, and I anticipate the forms and website and all of the kind of logistics of the program will be coming shortly, presumably before the new year. Employers can't claim an undue hardship with respect to foreseeable leave unless the employer establishes that in the specific context of the employer's business, the notice is insufficient. If medical leave is requested, this is the caveat. The employer's proposed schedule is subject to review of the employee's healthcare provider. So, easy example: if somebody needs to go and get cancer treatment from a medical provider, and that cancer treatment has to happen 10 days from now after they have this original appointment, the notice and subsequent schedule working out between the employee and the employer is subject to the healthcare provider saying, no, this actually needs to happen now. Additionally, one important change is that there's no more factors in the proposed rule regarding what an undue hardship is. Again, that's based on the facts and circumstances. With respect to the application process, if the leave is for a person with whom the employee has a significant personal bond, that relationship is examined also under the totality of circumstances. Factors regarding the significant personal bond includes shared financial responsibility, emergency contact designation, the expectation to provide care because of the relationship, cohabitation and its duration and purpose, geographic proximity, and any other factor demonstrating the existence of a family-like relationship. So this is really getting at, you might not be directly related to somebody, but easy example, long-term boyfriend, girlfriend, share an apartment, you share a house, you pay for those things together, you care for one another. There's an expectation of care that I'm certain would qualify as a significant personal bond under these proposed rules. Additionally, another change is that the Maine Department of Labor will notify both the employer and the employee of its application decisions, and that includes information on the amount of leave, the benefits paid. That, I think, will help the employer if it decides to supplement the paid family medical leave wages with short-term disability, for example, to see what supplemental wages might get the employee to their average weekly wage. State average weekly wage and an individual's average weekly wage is determined as of the day of application for benefits. Excuse me. Another change with respect to the fraud and ineligibility provisions is that the paid family medical leave fraud has now been clarified to include receipt of benefits based on a, quote, willful false statement. The addition of willful is the notable change here. Willful false statement, misrepresentation of material fact, or withholding of material fact. So if you purposefully leave out information on your application for benefits that would otherwise presumably disqualify you or prevent you from obtaining benefits, and you willfully do so, that would constitute PFML fraud. With respect to the premiums, all employers covered under the Act must register online for the program. From there, those employers can work with a TPA to do the premium payment and contribution reports. Withholdings will begin on wages for the first pay period with a payment date in January of 2025. And then for purposes of reporting wages on contribution reports, amounts will be reported to the nearest cent. And for purposes of calculating premiums owed, amounts will be rounded to the nearest whole dollar. For purposes of determining premium liability, any employer that employed 15 or more covered employees per that employer's federal EIN on their established payroll in 20 or more calendar weeks in the 12-month period preceding September 30th each year will be considered an employer of 15 or more employees. So you would look back on that reporting to see if you had 15 or more covered employees in 20 or more calendar weeks. Actually, just as a quick reminder, even if you are not an employer of 15 or more employees, you are still responsible for signing up for the program, and you are still responsible for submitting the premium payments for the employees that those employees owe themselves. With respect to private plan substitution, so if you'll remember, probably when the first proposed rules came out, all over the news and newspapers and TV programming, all anybody talked about was the private plan substitution, because this is an incredibly huge part of this act and these proposed rules. The law allows employers to substitute a private plan if they so choose, but how that looks has changed dramatically since the first round of the proposed rules. So now applications for substitution may be made after April 1 of 2025, which is about a year earlier than what the original proposed rules said. The application fee is $250 for review of the application, and then there's also an additional $250 administrative reimbursement fee if the application is approved for the substitution. The application fee may be increased on January 1, 2026, or thereafter based on the cost of administering the plans. So here, the biggest change is that originally under the proposed rules, the employer would be responsible for paying a year and a quarter's worth of premiums, even if they planned to substitute a private plan, which they may already have. And now, for purposes of what I'll call the fund-up period, all employers in the state will only be responsible for submitting premiums in the first quarter, and then those employers that intend to have a private plan will be able to apply and stop paying those premium payments after that first quarter, assuming that their application is approved. The exemption from obligation to pay premiums begins on the first day of the quarter in which the substitution is approved, except if the application for the substitution is submitted less than 30 days prior to the end of the quarter. So here, if you intend to substitute a private plan, applying on the first day or early in April of next year will be most beneficial. You don't want to wait until the end of the second quarter to apply, because you might be on the hook for premium payments in that second quarter as well. Notably, if employee withholdings were made prior to the substitution being approved, say, for example, the substitution was approved at the end of April and withholdings took place for all of April, the employer must then refund the withholdings to the effective date of the exemption within 30 days of the approval. So just refund that 0.5% of wages that were withheld from those employees. Whether through a fully insured or a self-insured plan, employers must start benefit coverage on May 1, 2026 at the latest. Employers or insurance companies for employers with fully insured plans must submit data reports by July 31st of each year, and failure to submit those reports may result in revocation or substitution. The employers must provide appropriate tax forms to the employees taking leave based on guidance from the IRS and Maine Revenue Service. One of the biggest questions I think that's still outstanding is what the taxability of this program and the benefits look like. The DOL has been trying to get that information from the federal IRS, as has every other of the 13 states, some of whom have had paid family medical leave programs in working for several years, and the IRS has still not published any guidance. That is anticipated at some point, and as soon as obviously we know more, the DOL will put forth forms that employers can share with those employees. Insurance companies may request certifications of a proposed plan as substantially equivalent. Notably, the Maine Department of Labor may delegate to the Bureau of Insurance the authority to review and approve plan applications for compliance with the Maine Insurance Code and compliance with the Maine Paid Family Medical Leave checklist that's jointly developed by the DOL and BOI. After determining an insurer's proposed plan is substantially equivalent, the DOL will issue a certificate of eligibility. The DOL may also use the same checklist to determine eligibility of a self-insured plan as well. So here, any number of insurers that may exist that may already be providing paid family medical leave benefits in other states will be able to go to the DOL and the Bureau of Insurance to apply to have their program approved, and they will then be able to show that checklist to employers to say, our program is approved, you can use this program, and that will suffice for offering benefits that are substantially equivalent to the paid family medical leave program. To be substantially equivalent, the plan must provide leave to care for a family member as defined under state FMLA law, and must allow for at least 10 weeks of aggregate leave per benefit year. So here, just as a reminder, substantially equivalent has previously been defined as providing substantially equivalent benefits, rights, and protections as provided under the program. The big change in my mind is that if you have a private plan, substituted plan, that plan may need to only provide 10 weeks instead of 12 weeks of leave. I imagine that is to follow more in line with state FML, which only requires 10 weeks versus federal unpaid FML, which is 12 weeks. expect that that's where the 10 weeks come from, but that's a pretty significant change, in terms of, an extra 2 weeks that somebody might be out on leave that is getting paid. A plan that consists of leave benefits that need to be accrued is not eligible for substitution. So if you have, similar to a PTO or earned paid leave program where benefits are accrued based on hours work, any program that does something like that would not be eligible for substitution. With respect to appeals, a couple of additional clarifications to the rules include that an aggrieved party can appeal the following issues to the DOL within 15 days of notification of the decision. Those new additions include a delay or denial of claim for benefits due to a finding of reasonable undue hardship, and any fine or penalty imposed, including fines related to late or non-payment of premiums. Notably, I can't remember if I included this later in the slides, but if a penalty is applied to an employer, that penalty will be 1% of the employer's annual payroll. So it is important to make sure that everybody's keeping track of making sure that either the payroll provider or the employer themselves are timely providing the reports, timely submitting the premiums, so that you will not have to pay the 1% penalty. The advisory ruling. So in the second round of proposed rules, the advisory ruling section is an entirely new section that I think will probably drastically benefit the program as well, in terms of how it's administered. So here, advisory rulings may be made by the program regarding applicability of any statute or rule administered by the program. All requests for advisory rulings must be made in writing. There's a list of requirements, what to include under the proposed rule. Issuance of advisory rulings is discretionary and will be made on a case-by-case basis, regardless of whether the Department of Labor or the program decides to issue an advisory ruling or not. The employer or individual that submits the request for the advisory rulings will be notified one way or another within 60 days. The program may decline to issue a ruling if any administrative or judicial proceeding is pending with the persons requesting the ruling on the same factual grounds. So you couldn't take this issue to court and then also request an advisory ruling from the program at the same time. No advisory rulings shall be binding on the program, provided that in any subsequent enforcement action initiated by the commission, any person's reliance on such ruling may be considered in mitigation of any penalty assessed. So here, if you, a couple years from now, there's an advisory ruling from a year prior, and you, based on that, make some decision as to what you are doing in administering this program as an employer, and you can show that to the program, any penalty that you might be assessed, for example, could be reduced or eliminated theoretically. With respect to an employer to-do list, so I've included an extra bullet point here, but on the Department of Labor website, the Paid Family Medical Leave website, there is a to-do list, and there's also a labor poster that you can put up in the conference room or the kitchen or some place that you might put other labor posters at the place of business. Here, the addition that I've made is to register for the Paid Family Medical Leave updates on the DOL website. It's very easy. Just type in your email and you'll get all the updates as soon as they come in. That has been very, very helpful over the last few months. You also will want to register for the paid leave portal in January. If you have not done so, you should prepare to withhold contributions and remind employees regarding their premiums. So have that conversation now so that, come first of next year, employees aren't wondering why there's a 0.5% taken out of their paycheck. That is, simply for required as part of this program. You also want to count your Maine employees. Here under the checklist, there's this, four step. And if the answer is no to the first one, you go down to the second one, no to the second one, you go down to the third, and so on. And for purposes of counting your Maine employees, you first ask, is the employee's work performed in Maine? Then if yes, then that counts towards the program. If no, you go to the second question. The second question being, does the individual perform some work in Maine and the base of operations is in Maine? If no, does the individual perform some work in Maine and is the service directed or controlled from Maine? If yes, then they're part of the program. And if no, does the individual perform some work in Maine? If yes, back to the program. This is all hopefully laid out in the FAQs, but also on this one-page to-do list that is provided on the Department of Labor website. Highly recommend to check that one out. With respect to other updates and guidance, I, through the course of studying up on this program and providing advice to employers on this program, have gone through and watched all of the FAQs videos that the department has had with the public and various employers. There are, I believe, 6 of those. The first roughly 20 minutes of every video is about the same, and it's just their summary presentation on what the program is. And then it's the Q&A session that has been helpful to kind of glean what the department is thinking and how it plans to interpret certain things. So here, the Maine Paid Family Medical Leave portal is coming this winter. The DOL anticipates being able to provide 2 demos in December. Again, every employer will need to register, and then they can note that a TPA will be filing on the employer's behalf. The same company that created the Maine tax portal is also creating the Paid Family Medical Leave portal. So hopefully the functionality will be about the same and easy to understand. Again, wage reports and premiums, as a reminder, for the first quarter are due in April of 2025. The DOL has also been working with a payroll provider consortium to prepare for the program rollout. So one of the things that they have advocated for in their presentations is that employers reach out to your payroll provider and just ensure that they've been contacted by this payroll provider consortium and getting guidance as a payroll provider in anticipation of this program. If they have not, then reach out to the DOL and they'll put you in touch with the necessary payroll provider consortium to start getting ahead of the premiums deductions and the reports that will have to come out starting next year. Again, the DOL has met with the IRS to request guidance on benefit taxability. It met with the IRS last spring or maybe early summer. The IRS, the federal IRS, had said that it anticipated publishing some guidance on paid family medical leave programs generally by the end of the summer. Clearly, summer has come and gone. It's been much colder in the last few days, but we still don't have any guidance from the IRS. Given what they have said to the Maine Department of Labor, I would hope that by the time benefits begin being paid, a year and a half, just about a year and a half from now, that we will have more thorough guidance on how this is treated. But for the time being, that's still one of the big unknowns. Guidance on state level taxability is expected following the next legislative session. Federal and state unpaid FML run concurrently with paid FML. And then, another important reminder that I think they continue to reiterate in every presentation, or most of them, is that employers cannot require employees to use PTO or sick leave while on paid family medical leave. That's different than unpaid federal or state FML. And here, if an employee goes out on paid family medical leave, they will have the right to still use their PTO or sick leave, at some other time. Notably, there is a 7-day waiting period for medical claims under the paid family medical leave program. So if an employee wants to use their PTO or sick leave to cover those, that 7-day waiting period, they can do so. Again, the Maine Department of Labor expects to provide some guidance on a look-back period. Many states, again, have a look-back period of 3 to 6 months. So I expect that will probably be forthcoming in the FAQs. The Maine Department of Labor also expects to provide guidance on how health benefits should be paid during leave. either by catch-up deductions or simply billing the employee for the amount of premiums owed. This is not a new issue for when somebody might be out on unpaid FML and how their portion of premiums for their health insurance, for example, is paid. But the DOL does anticipate providing some guidance on that in the coming weeks and months. Another just important thing to note is that the premium can be split in any percentage, provided that the employees paid no more than 0.5%. So if the employer wanted to cover 0.8 of the 1% and the employee pays 0.2, they can arrange that. I guess one thing before getting to questions, just on that last piece, as a reminder too, how the program, generally speaking, all employees of an employer will need to be charged the same premium. The caveat for that is that employers with different collective bargaining agreements can bargain among those groups for different premium payments for each group. So that would be the one other additional piece, that when you're figuring out what you as an employer want to pay for premium payments, that's something to consider as well. With that, we've left a few minutes for questions. I'm happy to answer any that have come in, and thank you. Hopefully this was helpful, as we only know so much before the final rules are published, but should at the very least give employers a good head start heading into the new year.
Great. Thank you so much, Jack, for that in-depth dive on the changes to the rule and the recap of the program. As we put in the chat, if you do have any questions, please drop them in there, and we will get Jack to answer them before our time is done today. I just want to take a moment just to provide a couple ways that you can stay engaged and informed about what's happening with paid family medical leave. As Jack mentioned at the top, this is still an evolving landscape. We don't have a final rule yet, and so we expect that in the coming weeks. By January 1st. There could be subsequent rulemaking changes over the next year as the program is rolled out and issues are identified. And there could be action in this upcoming legislative session to amend the statute that governs this program. So all of those are opportunities for changes that employers need to be aware of. To stay up to date about those, we recommend that you sign up for our advocacy updates. This is a newsletter that we send out with helpful links and resources, news about the program and the rollout. You can do that at our website, portlandregion.com, right on the homepage. Just scroll down and make sure to sign up for that advocacy update. Additionally, as Jack mentioned, the Maine DOL's website is a great resource, and you can sign up for their email updates there to get the latest news from the program, the final rule, FAQs, things like that, events, webinars that the department is holding, including those ones coming up in December about how to use and access the portal. And you can sign up for that at maine.gov/paid leave. I think, the most important takeaway, hopefully, for all of our members on the call this morning is that all Maine employers will need to register for the online portal on the DOL website by January 1 of 2025. Even if you intend to offer that private plan when that becomes available, all employers need to sign up, or, you do face the risk of some rather severe penalties. So hopefully that message got out loud and clear today. Should you have additional questions or problems become apparent as this program is rolled out in the new year, please do be in touch with me at edundon. That's my last name there, edundon@portlandregion.com. As I mentioned, we anticipate these additional changes and opportunities for amendments and changes to the rule in the upcoming legislative session. We can't advocate on your behalf in these processes if we don't hear from you on your concerns or questions with the program rollout. So again, you can reach me at edundon@portlandregion.com. And with that, I think we'll turn it over to the Q&A for a couple of minutes. We do have a couple questions that have come into the chat. The first is, will this recording be available after the session? And I can answer that one. We will have this recording up and available on our YouTube page in the next couple of days. And I believe that Riley Legier from our team will be sending out a link to that recording when it's available. The second question is from Mary. Is a short-term disability plan private coverage? Are they redundant? And I think this gets at a lot of questions employers are having about what does and does not count as a substantially equivalent private plan. So Jack, do you want to provide some insight on that one?
Yes. So the short answer is no. And I'll elaborate a little bit. With respect to what the paid family medical leave program benefits can be offset by, the program can't be offset by federal funds, TAMF or STAMP, any of those other types of funds. It also can't be reduced by short-term disability benefits. So if you have a short-term disability plan, that plan would apply to just the employee. And right now, currently, the rules have not been updated to provide clarification on what the limit would be. So you could have an employee that's eligible for both short-term disability and paid family medical leave frequently, not always, but you might want to talk with your short-term disability insurer to see what the coverage provision is. Frequently, those plans will also themselves have an offset for other benefits, so that employees won't be earning or receiving more than their average weekly wage, adding both the paid family medical leave and the short-term disability benefits. With respect to the private plans themselves, again, because this would presumably apply for just the employee and not pay for that employee to be out on leave to take care of a family member with a serious health condition, for example, that short-term disability plans are not plans that are eligible for substitution. Plans that are eligible for substitution are either fully insured plans that have gone through the approval process with the DOL or BOI, or they're self-funded plans that are subject to a surety bond on file with the program as well. But those two types of programs have to provide substantially equivalent rights, benefits, and protections as would apply to anybody under the program itself.
Perfect. Thank you, Jack. And building on that for a second, one question I've gotten a lot from our members is, say they offer today a private plan that pays out 100% of an employee's wages over maybe 6 or 8 weeks. Mm-hmm. And it's a richer benefit in monetary terms for the employee than what the state is requiring here. Would that count, or would they need to make changes to align with the rule?
My expectation is that would not count, because it would have to provide leave for the minimum 10-week period. If you provide for a longer period than 10 weeks, great. But my expectation is that the 10-week will be the threshold, even if it provides a richer benefit in other ways.
Great, thank you. And we still do have time for one or two more questions. If folks have them, please put those into the chat. Another question that I think comes up quite a bit, and hopefully we've hammered this message home today. But can you just review one more time how easy it may be for an employer to incur penalties if they're a couple days late or a couple dollars short on their expected premium contributions? What do those penalties look like, and what do employers need to be aware of to avoid those penalties?
Yeah, so I think it's really important that the employer works with its payroll provider to make sure that these reports and the contributions and deductions are all happening in a timely manner. So with the premiums being the easiest example, premiums for this coming first quarter, January to March next year, are due in April. All employers are required to pay premiums into the program. The employers that want to substitute plans can then apply in April to substitute their plan and not pay premiums going forward. But all employers will need to pay those premiums by the end of the first month following the quarter. So in April, you will have to pay by the end of April for whatever premiums are owed for that first quarter. If you fail to do so, the penalty that you could face as an employer is 1% of your total payroll for the year. So hypothetically, you could be looking at thousands of dollars or more, looking at total payroll for the entire year, not just the quarter that you would have submitted a late payment for. I think that this is intended to make sure that the program is always funded, and that the DOL has to spend less time administering plans or administering private plans in the course of trying to get this program up and running. Notably, too, if you do elect to have a substituted private plan, you will still be responsible. You won't be responsible for premiums, but you will be responsible for submitting quarterly and annual reports to the program to substantiate the fact that you are, in fact, offering benefits that are substantially equivalent. You do have this other plan. Those benefits are paid out in a way that is comparable to the paid family medical leave program. And if you fail to do so, you can have your substitution revoked, and I would presume a penalty applied as well.
Great. And thank you to Peter Gore for putting a finer point on that in the chat, saying all employers, regardless of size, should be prepared to pay at least 1/4 of premium to the state fund unless things change in the final rulemaking. And that's a really key message that we're hoping to communicate to folks on the call today. So I do see one more question, jumping back to the questions around short-term disability plans. The question asks, so we would want to keep the current disability plans until May of 2026, but may substitute the new DOL program after that date. Does that track with what you're talking about there, Jack?
Yes, and I think a lot of employers may still elect to have a short-term disability plan as well. That may help provide supplemental wages to the paid family medical leave program even after benefits begin being paid in May of 2026. But for purposes of from now until then, providing some wages to an employee if they need to be out for medical leave, for example, yes, keeping your current disability plan until then makes the most logical sense. Again, there has not been any rulemaking on if wages or short-term disability benefits and paid family medical leave benefits will be capped. In Massachusetts, there's a cap that says that those combined benefits can't be more than the individual's average weekly wage. I might expect that sometime in the near future, or as rulemaking unfolds, that there may be a cap. Again, sometimes there is a cap already built into the short-term disability plans themselves. So that part remains to be seen.
Great. And we do have one final question here, and then I will turn things over to Rachel to close this out. And that question is, when will final rulemaking take place? And maybe I could just add to that, while you're making predictions, do you want to make any predictions about what areas of the rule we expect there to be further changes in?
Great question. So final rulemaking is supposed to happen by January 1 of next year. There is obviously potential that the legislature in the next session amends the law, which then would require additional rulemaking. There also is potential that even after this second round of proposed rules and the hundreds of comments that were submitted, that the DOL decides, the portal is open and people can begin paying those premiums, but there are still things that need rulemaking considerations. So that there might be, another opportunity for the public to submit comments. But right now, as it stands, the timeline is that rulemaking by law needed to take place by January 1 of this coming year. With respect to what the rulemaking will consider, I think some of these offsets, certainly the substituted plans, is a big area of concern both for the insurers and the employers that intend to substitute those plans themselves. There may be additional clarification on what those advisory rulings look like, given that was an entirely new section in this last round. And I wouldn't doubt that there might also be some, additional clarifications on what constitutes, a familial bond for purposes of taking leave for for somebody that has a close family-like relationship to the employee. So those are all little things that have been tweaked along the way. Certainly, might expect more changes on those going forward too.
Perfect. That's very helpful. And as a final reminder, the legislature will reconvene in January for the 132nd state legislature. And so that's the earliest we could expect any conversations to start at that level about any changes to the statute. But as Jack mentioned, the most important things to pay attention to now are making sure you're signing up for that portal, talking to your payroll provider, and getting things ready to go for January 1st of 2025. And so with that, I will turn things over to Rachel Carruthers to close us out this morning. Thank you.
Thank you. Thank you to you both. Thank you, Jack, for an informative presentation today, and also for carefully answering everyone's questions. And of course, thank you to my colleagues Riley Legier and Eamon Dundon for helping to produce yet another successful virtual event here at the Chamber. Thank you for each of you for attending today and throughout the year. If you're interested in continuing today's conversation with Jack and learning more, be sure to check your email for a follow-up message with links to additional resources. Of course, I want to give another shout out to our sponsor, Eaton Peabody, for their support of this series. The Eaton Peabody Growth Basics for Business series is typically held on the third Tuesday of each month. Join us next month on December 17th for What is Direct Primary Care? Presented by Dr. Michelle Garcia, owner of Horizons Direct Primary Care, and Amelia Sponseller, board-certified family nurse practitioner and owner of Marshview Direct Primary Care. Michelle and Amelia will provide us with an overview of what direct primary care practices are, what they do, and how they differ from traditional fee-for-service practices, how they can best serve you, and why they are growing in numbers around the state of Maine. If you're interested in presenting at Growth Basics for Business, or you know of an industry professional who may be interested, please visit our website, portlandregion.com, to submit an event proposal. Any questions, our team's direct contact information can be found there as well. So with that, thank you again for attending today's event, and have a wonderful rest of your day.